All right, call your next witness.
Your Honor, sound like Daniel Morales.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Daniel Morales.
All right.
Mr. Morales, you've heard all of the testimony prior to this, correct? Yes, sir. And we had that discussion about the need for structure, correct? Yes, sir. But you recognize that if this judge were to look kindly on probation application, that none of that would matter if you not have the desire for this is Christ. And are you asking the court to grant you probation? Yes, sir. And if granted probation, you understand that there's a multitude of things that you can do that get you sent to jail for up to 20 years. Yes, you understand. You also understand that we know it was a back and forth with the relationship. Okay? Correct? But you understand that there's no more contract. There's no more contract. Y'all don't have any children together. No. But you do have a child. Yes. And part of the grandmother that I was talking to her, but also on your version, a lot of it, you don't want your son to be dealing with what you're dealing with right now. Correct? So you recognize that you need to actually have some training and accountability to get you to a place where your child can inherit your recovery. So, last question I'll have for you is, what does surrender mean? Um,
That's powerful. When a defendant uses the word surrender, it's not about giving up. It's about letting go of control, of ego, of excuses. Judges listen closely to answers like this, because sincerity here can tip the balance between second chances and hard time.
Yeah, you're willing to give up these pathways of reacting to situations in your life. And you're willing to accept instructions on how to respond as you made from your life, correct? Yeah, I'm willing to change something for myself. I'm for myself and myself. I will pass it.
All right, you may proceed.
Mr. Morales, how old is your son? He's 4 and 5. Okay. When your son goes up, he's involved in an altercation where he assaults, so for example, do you feel like he should be held accountable for doing so? I think it's his mother. So, yes, assault his mother, he should be held accountable. If he threatens someone's life, he should be held accountable. I'll pass it, Commissioner.
Any further questions?
Nothing from the others.
I have a few questions. Any objections?
No, no objections.
All right. So,
What we prefer, Judge, we would, in terms of the stipulations that we have taken to, we're probably done this before. I believe those are the same that we signed previously with the amendments that we had. Okay.
all right.
Now, this is where the judge shifts gears, moving from empathy to evidence. Notice how she pulls out his criminal history, one case at a time. 2 violent incidents, same victim, both involving deadly force. This is the kind of pattern judges use to measure real accountability.
So this is my concern and what I'm looking at. You have a case from September 16, 2024, with this complainant, and that's pointing a deadly weapon at her, namely a knife. And then you have a case from December 8, 2024, and that's another assaultive behavior against the same complainant, and this time choking her. And all of this over your breakfast not having ketchup. So, number one, what breakfast that you wanted did not have ketchup? This is just for me to know.
No, the only reason why I brought that up is because I was being cheated on and
No, 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 no. So here's the thing. When people cheat on people, you have two choices. One, you forgive them and expect that they're accept that they're cheating on you. And if they deny it, you either say, okay, they denied it, I'm gonna let it go. But your choices are either you stay and you accept it or you move on. So back to this ketchup business. So what breakfast were you having that you were so upset that there was no ketchup?
She was in she didn't have any, and I told her.
No, this is what, let me just tell you what the snips read. It says they spoke to the complainant. The complainant stated that they had been arguing since last night. You struck her on the face, and let me see, where is where you told her to let that BAN get ketchup for her. So this was over ketchup, and it was you who wanted the ketchup.
No,
It says that you wanted ketchup. So what breakfast was this? Eggs. It says complainant stated today they argued because she made breakfast and they did not have ketchup.
I don't eat my eggs. She told me she didn't have them, so I told him to go and go buy them.
Yeah. And so how does this turn into you grabbing a knife?
Because she has food I can't do it, and I can get my myself.
Okay. So that's in September. So you grab a knife in September because you can't defend yourself because she has people in whatever category you're talking about. So then the question becomes, if you think she's cheating in September, and you're telling her to tell some other guy to get some ketchup for her eggs, and you pull a knife on her because you're afraid of other people she has, then why are you with her in December?
Because when I got out, she told me she wanted to do it.
You know, why would you want to go back? She's cheating on you. She has these other people in some category that you're afraid of, and you have to pull a knife on her. So why would you even go back to her?
Yeah, she told me it's just a sugar daddy. It's just some old guy who gives you money. And,
So then we come to the December case, and the December case involves choking, and it says that she didn't immediately report because you're controlling and overhear her conversations and read her text messages. So it says that she contacted the babysitter to see if the babysitter come by. And when the babysitter came by, she let the babysitter know what was going on. So I'm assuming this complainant you were with has children.
yes, yes.
And when you say children, how many children?
She has two daughters and son.
And what are their ages?
I think her daughter was two. So,
2 and 6. All right, so you all are having these children see violence in the household, 2 and 6. You think she's cheating? She says she's not. Then she tells you it's a sugar daddy, and you're okay with that, which means you're okay with her doing whatever she does to get money, according to you, from a sugar daddy. And where was your child in all of this? This child that now you need to be there for, and you want them to see different things. Where are they?
I was seeing her every day. You know, that she didn't like me. She got out of my child.
And that's the other thing. Why would you be with somebody who you think is cheating on you, who has friends in categories that you feel you have to defend yourself with a knife by placing a knife on her, who then tells you it's a sugar daddy, and to top it all off, she really doesn't want you around your own child. Why would you be with that person?
Because I'm.
Did you catch that? He calls it a mistake, but the judge immediately corrects him. These are choices. That's a classic moment in courtroom dynamics. Judges often challenge word choice to test whether a defendant truly accepts responsibility or is just trying to sound remorseful. What do you think, genuine regret or just performance? Comment below.
No, these are choices. These are not mistakes.
It's my choice. My choice changed.
All right. And what's with this tattoo on the face?
They just say her name, but I told you it's my baby.
All right. So, and then you get her name tatted on your face. So you get her name tatted on your face. Don't even have your son's name tatted on your face.
No, no.
As a side note, this is what I always tell people. When you're getting tattoos of people's names, these are your best options. Your mother, because your mother's supposed to always love you, and your children. Getting names of females or males, never a good idea. And what's with this San Antonio tattoo? Do you love San Antonio that much that you need that tattoo? What's that about? Oh, a lot of people are born here. We don't have a San Antonio. How many people are born here in San? Do you have a San Antonio tattoo?
I don't even.
So what's that really
I
about?
love saying I really I I like how that is.
And then it says 210. Yeah, what's going on with the tattoo?
Like I said, it's just well,
Alrighty, is that your story? You know, you stick to your story.
yes,
What's that tattoo about?
like I said, it's just
Nobody.
I don't know for me.
I don't know. You can ask whatever questions you want to ask counsel.
The environment in which you were raised, I think you probably get to what the court may be alluding to.
Look, are you a gang member?
No,
So why do you have that tattoo?
yeah, sure. And if you did, it would be more along the lines of like thousands of people in San Antonio. Posers, for example, there's thousands of people in San Antonio who unknowingly have, for example, the Michael Jordan jump design on their arms. They think it's cool on other people, not understanding what connotation that has with actual gang members who are danger to the society and probably shouldn't be. You understand that, but as basically a kid, how old were you when you got this? How about you? Okay, so, oh, were you 21? Okay, so as a 21-year-old, not fully understanding the ramifications of certain things, you personally just thought it was cool. That nothing to do with me. You know, I just got it because I tried to do best. Okay.
Any other questions?
So just started.
All right. All right. In each of the cases, court does. I don't think you're a good candidate for probation unless the complainant is going to walk in here and says that she wants you to have probation. It's not happening. I'm going to find you guilty in each cause number. You all have.
Your Honor, will we able to make argument or support just?
I'm finding him guilty. You all can make an argument as it relates to the cap. All right. So it's a cap of 5. The court will hear argument.
All right. In support of Chapter 5, Your Honor, the defendant has a long, violent history. Essentially, 2020, he took violent offenses. 2020, he assault. I was unable to get to a city office to determine the facts regarding him. He served 5 months deferred. In 2021, he had a misdemeanor, ABI family violence. He did JSAT on. Following the convictions of another class CSL, he has 5 months probation on. 2023, a charge of threat, family violence, it was 8 months to prove adjudication on. And these two all within the same year we're looking for today. There are actually 3 cases, one's being TIC. As part of the plea, I feel that because this defense long violent history, he is not a candidate for probation and presumably was.
All right. Defense.
Well, Your Honor, we would ask for considering the lower end of the cap in this case, which is 2 years. He's expressed qualification. Of course, in these cases, there are always what we would say in terms of complainant, which guess we wouldn't do this motion to the court. My understanding is that the state, that the complainant is moved out of state and that they're more here. So, if the court would give this time a possibility to investigate and try to bring her to start, if she has an issue with probation, we would ask the court leave to possibly do so. But if the court is not so inclined to allow the state to try to reach out for us to reach, we would ask the court to come on the lower end of the rank to. He understands that there are cases that are done differently. We're also very, very careful in making sure that we're not blaming the quote unquote victim in any way in these situations. But what we will say is that she was a much older than the defendant. There was a significant amount of manipulation. But again, um, which is why we presented that evidence to the court. We believe that we didn't have the background to be able to develop the ability to react in a way that would be within the guise of the law, as opposed to ways that could be construed as criminal offenses. Um, Given his age, given his support structure that he has, We would ask the court to come in we would ask the court to give him a sentence of 2 years on this case, and we would also ask the court if the court would be willing to uh, maintain jurisdiction over the case if the court were inclined to give him anything over.
All right. And each cause number, the court has previously.
This is it, the final judgment. Despite the emotional pleas, the violent past and repeated offenses weigh heavy. The judge isn't just sentencing Morales to prison, she's making a statement about accountability, safety, and the limits of mercy. 5 years. A painful but predictable outcome, and maybe a wake-up call that surrender alone isn't enough. It has to be followed by change.
Stated is finding you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence in each cause number. There should be no contact with the complainant. Taking consideration 2025 CR 002680. There should be no unsupervised contact with minors. There should be no residing with any household that has minors. And our request therapeutic community in each cause number. In each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? All right, because these are plea bargain agreements, because I followed your plea bargain agreements, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Counsel, I'll retain jurisdiction. We'll see how he does. All right, thank you. Up to you.